briefly go through a few of the questions I asked him. I mentioned news reports about the pervasive culture that we read was in the division, that many senior lawyers, supervising attorneys, and others believed the civil rights law should not be enforced in a race-neutral manner and should never be enforced against blacks or other national minorities. And I asked him whether when he came into the division, since he was in charge of the transition for the division, that he was certainly aware of these, well, for the entire department, he was in charge of the transition, what steps he took to investigate that culture of the division he was inheriting. And he refused to say that he did any investigation, except to say that he didn't believe anyone in his division had those views. So I took that to be a denial that he did any investigation. I asked him about other press reports at the time the new our investigation began, and members of Congress, whether that the Washington Times, for example, said the motive for dismissal was this caustic view that the civil rights law should never be enforced against blacks and other minorities. I asked him whether he took any steps to investigate that. He did not. I asked him about Coates' statement. I said, Coates, your voting section chief, resigned and gave a statement that he thought that was an improper. Did you ever talk to Coates? He denied he did that. And then I asked him what he would do if others in his division had such views. And so it's particularly important to me to ask about these Julie Fernandez statements, because Julie Fernandez, is it his principal deputy, his most senior deputy, or is she just one of his deputies?
I don't know the answer to that. You can look on the website. She's the deputy over voting, so that's all that mattered to me.
Okay. This statement that Coates told you about, where she essentially gave an instruction, as I understand your testimony, and I've heard it from one other source, Julie Fernandez, the Deputy Assistant Attorney General under the Obama administration, said that the voting section will never, or will not, at least while she's there, bring any more cases against blacks or other national minorities. Is that essentially what you heard?
Well, it is. It is what I heard, but bear in mind what I talked about in the U.S. v. Ike Brown Section 5 submission, where even if they did bring a case in the next couple of weeks, it would be inadequate given the power they have to object to that racially discriminatory submission as it stands right out of Washington. They don't need to go to Jackson to do it.
I understand. I'm going, at some point in our investigation, I'm going to not only re-urge that we to try to press the department to allow us to hear from Chris Coates. I'm going to ask that we seek a subpoena for Julie Fernandez as well. But based on what you've heard about that incident, she supposedly said, well, it may be brought by U.S. attorneys, but not by the Civil Rights Division. Is that? I mean, that's pretty shocking to me. Do U.S. attorneys have the expertise to bring voter intimidation or other?
I mean, voter intimidation is so simple they could probably do that. But Section 2 cases, absolutely not. It's one of the most complex areas of law, bar none. Maybe antitrust, but either that or Section 2.
Yeah, even if Obama administration U.S. attorneys are going to bring this, it's still troubling to me that Julie Fernandez would issue this edict. Who else was present at the meeting besides Coates?
You'd have to ask Coates.
Okay, last question, Commissioner Gaziano. You can follow up during the second round. Commissioner Kirsnow.
Thank you, Mr. Chairman. And thank you, Mr. Adams. Your testimony is easily, I would think, the most extraordinary I've heard in the 9 years I've been on this commission. And I would suspect that in the 50-plus years of the existence of this commission, it ranks way up there. We've gotten considerable resistance from the Department of Justice regarding our requests for information. The same resistance was experienced by Congressman Smith and Congressman Wolf, and but for your resignation, I suspect that we wouldn't even gotten close to the testimony or the evidence adduced in your testimony today. I've just got some summary questions to ask. Most of them I think are susceptible of yes or no answers. To the extent they implicate any privileges, let me know. Based on your testimony, to what extent can Americans rest assured that the voting rights section of the Civil Rights Division will extend equal protection or equal treatment to all voters in terms of their prosecution of the Voting Rights Act?
Well, to what extent is the big mystery. Let's hope that they object to the the Ike Brown submission next week. They probably won't, because they don't believe Section 5 applies to white voters if they're victimized. Let's hope they don't just try to sue and cop out and stop what he's trying to do. Let's hope they object. We will know more about the answer to your question after July 14th. If they do anything other than object, clearly they will be announcing for everyone to hear what they think about your question.
As you sit here today, do you feel confident that Americans can be confident that they will be extended equal protection or equal treatment by the section?
If the department objects to the Ike Brown submission, I will begin to change my mind about their attitude. If they do anything other than object, I will not change my mind.
Taking the adverse of the new Black Panther Party case, if a member of the Ku Klux Klan or the National White People's Party or the Nazi Party, Aryan Nations, was stationed outside a polling place with full respective regalia, Klan outfit, Nazi Party outfit, carrying a baton, shouting racial epithets and making threats, would you consider that to be something that is an 11B violation?
Okay. I don't want to err by not hearing one of your facts, but as I understand your question, it was the Klan out in front of a polling place in front, I assume, meaning at the entrance, shouting racial epithets. Did they have a weapon in your fact pattern? I'm sorry.
Batons similar to that carried by the...
There's absolutely no question about that. I mean, to brandish a weapon, which a nightstick is, the department, on many cases involving criminal matters, have viewed a nightstick as a deadly weapon. There's case law in that regard. To have a deadly weapon like a nightstick in front of a polling place in Klan regard, I mean, everyone here knows the answer to that question. We don't even need to ask it. It's just reality.
Right. I'm going to ask you a series of questions that I think may be susceptible of inaccurate, false, incorrect, however you want to respond. I understand it's your position that no one in this particular case has lied, that is, had an intent to deceive or mislead. But based on some of the testimony we've heard thus far, prior to your testimony, I'd like to ask you the following set of questions. Did career attorneys, rather than administration political appointees, make the decision to dismiss the new Black Panther case?
I see where you're... In my mind, and I think in the minds of anyone who fairly reads the Vacancy Reform Act with credibility, political appointees made the decision.
Okay. Was the totality of law and facts such that it dictated dismissal in this case?
That's one I won't answer.
Okay. Is this a case that would subject DOJ attorneys to Rule 11 sanctions?
That's one of the most outlandish things I've heard throughout this whole affair, that we were in violation of Rule 11, and it's personally offensive because it's not true.
Is it accurate or inaccurate to say that this case could not meet the allegedly high standard required under Section 11B?
Look, someone could file this case tomorrow. One of these victims could go out and file this. It would be an enormous embarrassment to the department if that happens, and I hope it doesn't happen, because I hope the department refiles this case. They would win this case if a private plaintiff brought it. I believe that they would ultimately win this case, probably because the Panthers won't show up again, or they won't. As I understand it, they weren't even cooperative here, and so assuming they even show up on the merits, they're going to have a very difficult time losing this case from the plaintiff's perspective.
Is it common or unusual for DOJ to dismiss a case that's essentially already prevailed upon on default?
Chris Coates is someone who you should talk to because his institutional experience goes back further than mine. And you have plenty of other former DOJ people. I think Mr. Katz has testified, I may be wrong, that this is unprecedented.
Thank you,
Mr. Chairman.
Commissioner Taylor.
Thank you, Mr. Chairman. Mr. Adams, I wanted to talk to you about this culture issue within the division.